Hi, this is Rich Bevelheimer with HMA Legal Funding. This video is an introduction to litigation funding. We're going to go through just some of the basic uses of litigation funding to try to create a basic sense of awareness. We are a boutique brokerage firm specializing in funding meritorious commercial and personal injury cases. We do work at what I would call the mid-range of the market, $250,000 or greater of settlement value, and probably our sweet spot is right around $1 million of settlement value. This slide says we have a whole bunch of experience and we all think we're really smart. Okay, let's get into this thing. Litigation funding simply allows the plaintiff and the plaintiff's attorney to immediately monetize the expected settlement values. And I use settlement, judgment, recovery. You'll have to bear with me because I'm just a CPA, not an attorney. So when I'm using settlement, it means you and your client got some money. All right, so we can use funding for the plaintiff. We can use funding for the attorney. Any of our fundings are non-recourse. What that means to you is that if you zero out on the case, you do not have to pay it back. The second important thing is that this is a passive investment on our part. What that means to you is we have no control over how you litigate the case, and we cannot force you to take a settlement. You do have unrestricted use of funds. We don't charge you for the privilege of putting in an application. We will underwrite it, and, free of charge up front. And this is off balance sheet for the attorney, so it's not going to affect your credit rating. How you would use the money is up to you, but typically living expenses for the plaintiff, case costs such as depositions and expert witnesses and life plans for the attorney, and it does allow you, as I said earlier, to monetize the illiquid asset. Okay, let's talk about distribution of funds a little bit. The key to all this is to have a case where we can advance you an amount of money that is less than or equal to 10% of the money you're going to receive in the settlement. So a perfect case, I guess, would be $1 million settlement and a funding of no more than $100,000. Everybody asks me, what's it cost? And it's more than bank financing, it's more than a line of credit, but it's also non-recourse. So we are putting ourselves in a position of alignment with you and your plaintiff, you being the attorney. So that said, typical cost of funds runs between 0.8 and 1 times the amount of money advanced. In other words, in this case, $100,000 was advanced. You are going to return to us at settlement that $100,000 plus somewhere between $80,000 and $100,000 of cost of funds. Okay? So what that means is if, as an attorney, if you need that $100,000 to get the depositions and the expert witnesses to drive that settlement from, say, $500,000 to $1 million, then it's worth it. All right, let's talk about some examples, and I use some really small examples to try to keep this in everybody's frame of reference. But let's say we've got a case and we were offered by the defense $150,000. But if we know if we can get, we suspect if we can get some more depositions, another expert witness, that we can drive that settlement offer up to $300,000. We can double it. $30,000 of additional costs in the form of an advance will get us there, and that would make it worthwhile, in my humble opinion. Okay, so that's the typical scenario that we see. Driving, not having to settle early because your client needs money, and being able to get the best settlement value for your client, because the defense knows that you're fully funded, that you've got the ability to take depositions for an extra day. You've got the ability to hire another expert witness. Put them back on their heels. Create a level playing field. All right, on this one, we're talking about a good problem to have. You typically carry 48 cases. You've got the ability to potentially handle another 25% greater cases, 12 more cases, but those case costs are going to be $10,000 a case, another $120,000. Well, if you use litigation funding, you get a $10,000 advance, you're going to net another $360,000 that year. How do I get that? I take 12 cases times the 40% contingency fee, $40,000 a case, times 12, get $480, and I subtract $10,000 a case, assuming that it's a 1x pricing. You're going to pay us back as a cost of funds, $10,000 per case, times 12, $120,000, $480 less $120 is $360, additional income to the attorney or the attorney firm. All right, let's talk a little bit about risk transference. Obviously this is non-recourse funding. That means that if you zero out, that you don't have to pay the money back, it's on us. So if you've got several cases and you envision this on an ongoing basis, if you were to take every second, every third, every fourth case over a period of time and fund those cases, then you're going to transfer that risk to HMA legal funding. Okay, that's us. That's our website, obviously. These are the people that you want to contact. I would suggest that email is the best form of contact. You can contact Micah at her email address there. You can contact me, Rich Bevelheimer, at my address. You can contact Grant. On a typical personal injury case, we're going to want the complaint, the defense pleading, the police report, any hospital or doctor reports, a brief one-page summary of the case with your expected settlement value. And I know we talk about settlement values and you can't predict it, but you have a pretty good idea. All right, so with that, I'll sign off. Give us a call, and we'd love to hear from you.